Tribunal in the matter of Gadinala and the Secretary of State for the Home Department.
Ms Chapman, before you get onto the substance, should we deal with the question of anonymity?
My Lord, yes. The issue, as I think your Lordship's, your Ladyship are aware, really to do with the underlying facts, not just specifically in relation to the appellant, but in fact more in relation to his children who bear his name and his partner who doesn't bear his name, but in respect of whom some very personal details are included in the papers. That simply is the reason for the request, to protect the interests of, in particular, the children and his partner.
Mr Tabori, is that something on which you have a position or not?
No, we are neutral on that point.
Members of the press here.
I take it there are no members of the press here.
They may be on the live stream.
Of course, that's right.
The appellant and his partner are here.
I wonder if we should just go up one moment.
Rise if they will.
Sorry, can I just ask?
Yes.
Besides this specific point that you're making in relation to this?
So the point I'm making, I wanted to just read those two out.
Right.
Because I think there is disagreement about the third principle in Akanyemi. And this is because no one else in Heshimali sort of said, oh yes, we agree with Lord Carr. So the other paragraphs are Lord Wilson's paragraphs, which are...
Okay. Additional revulsion expression.
Yeah. And Wilson then resiled from using the terminology.
Yeah.
But the principle, the third principle, is still there. Society's disapproval of it.
Okay, thank
And
you.
we're not saying that the UTJ used inappropriate language, but what we are saying is ultimately for him, the case really fell on that third principle, which it did.
Right.
I suppose arguably you'd say that both were.
I mean, I think the problem is it's not just a question of look how revolted the sentencing judge was. It's the specific disregard of guilty plea and other measures of seriousness.
In the first degree judge.
Yeah.
And we say, of course, well, you know.
Sorry, this is about ground.
Yes.
Oh, okay.
Rise if able.
Ms Chapman, we're not persuaded that an order for anonymity is justified, and the intention is to say something more about that in due course in the judgment. At the same time, we do understand your concerns, and we would hope that they can substantially be met by all of us trying not to refer to those sorts of details. And given the nature of the appeal, it's hard to see why we should need to go into any of that detail, or the broad sweep of things is perfectly clear.
Yes, the findings of fact were preserved, so
Yes.
hopefully one won't need to reopen or refer to those
Yes.
in any great detail.
Yes.
I'm grateful. My lord,
Yes.
my lady. Perhaps if I can start at the beginning with ground one, unless there's any reason to
No, and I
do
should say
that.
we've all obviously pre-read, so we're familiar with
Yes.
the decisions and the materials.
So it might help, therefore, to then turn to the decision of the first tier tribunal judge, which is this, along with the decision of Upper Tribunal Judge Rental being the focus of the appeal today. Our first ground of challenge essentially is that the Upper Tribunal erred in law in overturning the decision of the first tier tribunal judge. And this was based really on a single word or a single sentence. So if we turn to that, and it's
This is paragraph 129, isn't it?
It is, yes. Which is page 126 of our bundle. And it's acknowledged what it says, which is that here the only indicator of the seriousness of the appellant's offending is the sentence imposed. And the only conclusion which can sensibly be reached from the sentence of 8 years imprisonment is that this was serious offending. What is clear, though, in my respectful submission, is that the reference to the word here is clearly referring back to previous paragraphs and to the specific context of this case and the judge's findings. And in particular, if one looks back on page 125, the heading Public Interest Factors, the judge there correctly directs herself in respect of the judgment in Zulfikar and makes the point that the most significant factor is undoubtedly the very serious offence committed by the appellant. So, in fact, what's clear here is that the judge isn't in fact saying it's the only issue of seriousness, but it's the most significant factor. In addition to that, it's clear from the judge's analysis of the case as a whole that she had in mind a number of other relevant points. So paragraph 27, page 110, this is in her summation of the factual history.
Sorry, paragraph
27, page
Yep.
110. 27 of the first tier
Yes.
judgment. On 24th of September 2030, having pleaded guilty to the charge, the appellant was convicted of aggravated burglary and was sentenced to 8 years imprisonment in the Young Offenders Institute. The appellant had committed the offence in February 2012, less than a month after his 18th birthday. So there are a number of relevant points there. And then, although this is under the heading of the Section 72 certificate, and just a brief explanation about this because it hasn't featured further, Section 72.2 of the Nationality, Immigration and Asylum Act 2002 permits the Secretary of State, or in fact mandates the Secretary of State, when applying this certificate, to do so if the person has been convicted of an offence and sentenced to at least 2 years imprisonment, and there's a rebuttable presumption that the person therefore constitutes a danger to the community. So the certificate was applied in this case, and the judge's consideration of that certificate begins at paragraph 43, page 112. And the reason that this is relevant is because as part of that consideration, the first tier tribunal judge was required to look at the seriousness of the crime, of the offending. And she does this in some detail at paragraph 45 onwards, noting firstly what the appellant said about it, then noting the submission Mr. Tamlinson represented the Secretary of State, his submission that the appellant was still a danger, and importantly at the end of paragraph 46, the judge states, "I note the sentencing judge's remarks at the time of his sentencing in 2013 was that the appellant posed a significant risk to the public of serious harm." So the judge had that sentence and the sentencing judge's remarks well in mind. So the issue was, given the passage of time, whether that risk had been reduced. At paragraph 48, the judge looked at...
Forgive me for interrupting you.
Sorry.
Just staying with paragraph 46,
Yes.
if we may. In the middle of that paragraph, the FTT notes that the sentence was one of 8 years imprisonment. Strictly speaking, it's detention, but we can leave that semantic point to one side. But she also notes that there was an extension period of 4
Yes.
years. But later on at paragraph 129, is it your submission that when she refers to the sentence imposed, that she had in mind more than the sentence of 8 years imprisonment? She doesn't, at 129, she doesn't appear to refer back to the point that this case was relatively unusual in that there was an extension period. In other words, an extended sentence was imposed.
Yes. My lord, yes, it is. I mean, it's 129 is very short. And so it isn't in that sense a summation of all the factors that we say in fact were in her mind
Yes.
during the course of writing the judgment, as is clear from paragraph 46. I think there is also further reference to the extension period, which we will get to.
Right.
So I would submit that this isn't something she put aside when undertaking the final proportionality assessment
Yes.
and analysis of the seriousness.
Yes. I see. Thank you.
He was still within the extension period, wasn't he, at this stage?
I think he is until September next year for my calculations, because it was 12 years from sentence, which was in 2013, September 2013. But there has, and I don't think Mr. Tabori would disagree, been no reoffending or any breaches of the conditions in the period of time since he's been released from immigration detention, which is now about 7 years. So at paragraph 48, the judge there states, I've considered with care the OASIS report and the probation officer's covering letter, dated 3rd of September 2022, which states there are no concerns about negative behaviour on the part of the appellant. I probably don't need to trouble the court with those. They are quite brief and they are in the supplementary bundle. Essentially, they were commissioned for the appeal, just at that point to see if there were any concerns and for a risk assessment. And then the judge at 50 states, what I find extremely relevant is the level of risk of reoffending, which was 2.6% over the next 2 years. And then at 52, the judge says, following his release, the appellant has spent his time on licence without incident, has not committed any criminal offences in over 5 years since he was released from immigration detention.
Can we just go back to 50, just really to put it in context? I noted that the judge, the FTT judge, had been interested in the risk of reoffending, which I think was the assessed risk.
Yes.
But this was a case, and again, it is quite unusual whether the appellant had been assessed as dangerous
At the point of sentence.
at the point
yes.
of sentence, by the trial judge, and that
That's
was what had led to the extended sentence.
So clearly there was quite a big shift,
Yeah.
but that was evidenced by the probation officer and the OASIS. Would it help, my lady, to look at the
I have
reports?
read it. Now, in your hands, I've seen
I mean,
it.
it is extremely brief, but just so you can note its existence. So it's in the supplementary bundle B65 and B66. B65 is the letter from Siobhan Popula, dated the 13th of September 2022. Although interestingly, the licence, rather than extended licence period, expired in February of this year. I'm not exactly sure how that works. But
You think the arithmetic looks strange?
well, only because counting the time, it would seem it was September of next year.
Did he spend time on remand?
My lord, yes, possibly that's why then it will be
Yes,
discounted backwards.
exactly. So that probably explains why the ordinary licence period has expired
Yes.
earlier this year. But my understanding of the way in which an extended sentence worked is that the extended licence period is then added on to the ordinary licence period. I hope I've got that right. So it seems to me, at least, without doing the precise arithmetic, that your initial submission was right, that we are still in the extended licence period.
Until September next
Yeah.
year. Yes.
Or at least some date in the future. But the point is that for an 18-year-old offender, that's a pretty unusual sentence to impose. I can't remember now. Help me. Had he served a custodial sentence previously?
He did have convictions, but I'm
Yeah,
not
yeah.
sure that he had.
Yeah.
of that.
But even if he had, it's certainly from my experience of having sat in the Crown Court, and I think my ladies as well, this would have been a pretty stiff sentence to impose on
Yes.
someone who had just turned 18 at the time of the offending, which perhaps gives us some indication of how serious it was.
I see in the sentencing remarks there's reference to previous referral orders,
Yes.
youth
Yeah.
rehabilitation orders, and conditional discharge.
I'm grateful, my lord. C34,
Yes.
the same bundle.
Thank you.
So in fact he hadn't. But yes, we say clearly the sentencing remarks and the sentence itself reflected the severity of the offence, and the fact that the appellant was the ringleader in relation to two younger defendants who were given also quite long sentences, but commensurate with their role. The appellant's was higher to reflect the increased severity of his role and in the offending. I was going to take your lordship, your ladyship, to the sentencing remarks a little later.
So just before you move on, you were taking us, I think, to the probation
Yes,
service and
probation
the OASIS
service.
assessment.
Yes.
So B66, we see the likelihood of serious reoffending over the next 2 years, 2.6% low. We do also see on the next page.
Yes, so this is an extract from the OASIS assessment, risk of serious harm. Well, in fact, it does stand on its own 2 feet. Sometimes these documents are about 50 pages, but this one is only 3 pages. So it's, and again, it was quite recent, 12th of July 22. So it was prepared at that point in time in relation to the risk at that time.
Yeah.
We do. I'm just seeing if we have. We obviously haven't put in the entire documentary evidence from the first year because it was quite substantial. But often there are a number of these reports going back over periods of time. But obviously the focus for the judge was the point of her assessment, which was the date of hearing. At which point the evidence was that the risk of offending had been massively reduced, and the risk to the public, which I think was medium, was also massively reduced from someone who had been considered to be dangerous at an earlier age.
Yeah.
Yes, I think so. We went back to 48 and 50. Again, 52 at the bottom of page 113 of the first year's decision. There's reference to the fact that he has spent his time on licence without incident since his release from immigration detention. And then at 54, a summary really, there's no dispute the appellant has committed a very serious crime. I consider the offence was committed over 10 years ago. There is no reoffending in this case and no concerns raised by the probation officer about any current poor behaviour or circumstances which would cause concern. the risk of offending is assessing at below 3%. The appellant's been living in the community since 2017, and in this period, which exceeds 5 years, there's no indication that the appellant's behaviour constitutes a danger to anybody. So obviously that's a reserved finding of fact. As referenced again at the next paragraph, the judge said, "I'm persuaded it's likely the appellant is a much changed person from the menace who committed such serious offences in 2012. And again, making a positive assessment that he has changed based on what she has seen. At paragraph 56, the judge acknowledges, whilst it's impossible to make concrete predictions about the future and required to make an assessment, I don't think that is, but probably if the appellant constitutes the danger to the community of the United Kingdom. Acknowledging again that he was a serious risk, clearly a serious risk in 2012 when he committed the offences, but that he wasn't at the time of the hearing before her. And again, reference at 57 to the fact he's now a very different person to the man who committed the particularly serious offence over a decade ago. So that was the basis of the judge's conclusion that he'd rebutted the presumption that at that point in time the appellant constituted a danger to the community of the UK.
So in terms of where you're going,
Yes.
you would ask us to have in mind that the judge had in mind that it was a particularly serious offence, that it was a very serious offence, and also that the judge was aware that there was an extension period of 4 years and had read the sentencing remarks with care.
My lord, exactly. And just for the avoidance of any doubt, at 41, so page 112, the judge does state in terms her approach to the drafting, where she says, I confirm I've considered all the documentary evidence submitted and oral evidence provided before coming to my decision. And importantly, you'll see from paragraph 39 that the judge had the benefit of oral evidence in English from the appellant, his partner, and also his sister, which wasn't something that the Upper Tribunal judge had the benefit of. In part, of course, because the findings of fact in the appellant's favour had been preserved and the Secretary of State wasn't seeking to reopen them. So there was no need as such, although the appellant and his partner were present and willing and able to give evidence if need be. But reverting back to paragraph 41, the judge says the findings I've made were only reached after consideration of all of that evidence in the round with anxious scrutiny. For clarity of drafting, I've separated my analysis of the evidence into different subject areas, but I stress I've considered all the evidence concerning all the subject areas holistically. So, and this is partly because the nature of deportation appeals, there tend to be at least probably 4 quite substantive issues to decide. And so, as the judge quite sensibly has set out, this is the way that she's decided to do it, but in fact looked at everything before then reaching her judgment with these subheadings, which your ladyship will have seen. The judge then looked at the human rights appeal aspect of the case. That begins on paragraph 84, paragraph 84, page 119. And that's essentially where the findings are made in relation to the appellant, his partner and his children. There is one point I wanted to highlight, and that is at paragraph 123. And this is with reference to whether the appellant was socially and culturally integrated. Sorry, it's page 124. About just after halfway down that paragraph, the judge says, although a very serious incident of offending, the convictions are the only time the appellant has come to adverse attention. That in fact is not quite correct, because he did have the previous offences, but they weren't imprisonable. He wasn't imprisoned for them. The appellant's response to his crime, his early guilty plea, his remorse and acceptance of his sentence, and his clear reintegration following his sentence are all clear evidence of his acceptance of the rule of law and wider integration in the United Kingdom, notwithstanding his conviction. So that was in the context of the integration aspect. And then we reached the final sections, which are quite short, because in my submission they're predicated on the findings which had been made previously. So the next heading is very compelling circumstances over and above the two exceptions. Now, because of the length of the sentence and the extended licence period, well, in fact, just the sentence on its own being in excess of 4 years, this is the relevant test under Section 117C of the Nationality, Immigration and Asylum Act 2022. And the judge had well in mind that test. She correctly, at paragraph 125, adopted the balance sheet approach, having regard first to the public interest in deportation and then to the competing factors raised by the appellant. And at 126, makes that point: the public interest requires deportation unless there are very compelling circumstances over and above the two exceptions. Now, the first exception was that the offender has spent half of his life. She finds against him on that. But in relation to the second point, whether it would be unduly harsh for his children and partner to remain behind in the UK without him, she found in his favour, but that's not sufficient. So the issue, as she's well aware, was over and above that. The judge referred herself to the Supreme Court judgment in HA Iraq, where the court held all the relevant circumstances of the case will be considered and weighed against the very strong public interest in deportation. And then, this is paragraph 51 of the judgment, we probably don't need to turn to it. Essentially, these are the so-called Bultif criteria in italics in paragraph 126, that relevant factors in that assessment are the nature and seriousness of the offence committed by the applicant. And then the other factors are the length of stay in the country, the time elapsed since the offence was committed, the conduct during that period, the nationalities of the persons concerned, the family situation, solidity of social, cultural and family ties with the host country, with the country of destination. So in a nutshell, the nature and seriousness of the offence has to be balanced against all those other factors. Again, I don't think it's disputed that that's the correct test. Then the judge goes further when looking at the public interest factors, paragraphs 127, 128. 128 is just a reiteration of the Section 117C test. But the judge again at 127 says the most significant factor is undoubtedly the very serious offence committed, and then refers to the judgment in Zulfikar and the 3 reasons why deportation of foreign nationals who commit such serious offences is in the public interest. So the risk of reoffending, the need to deter foreign nationals from committing serious crimes, and the third criteria, maintaining public confidence in the system. And directs herself, these are all factors which must be given considerable weight in any assessment of proportionality. And then lastly, looking at paragraph 130 over the page 126, the judge finds, I've identified the reasons for public interest in deportation above, and while my finding that the appellant does not pose a serious risk of reoffending might dilute the first of the 3 factors behind the public interest, it does not affect the public interest in deterring foreign nationals from offending and in maintaining public confidence in the system. There is therefore a very strong public interest in the appellant's removal as a result of his serious offending, which must be given significant weight. the balancing exercise just over the page 127, paragraphs 137 and 138, again is referring back to the paragraphs I've just read. It is clear that the judge in my submission had well in mind that there was a very strong public interest in deportation of this appellant as a result of his serious offending, and that must be given significant weight because that is what she says. And then at paragraph 137, returning to the balance sheet exercise, what she describes as weighing the competing sides of the scale, I start with the recognition that the public interest in seeing foreign criminals who commit serious crimes in the United Kingdom removed is substantial, and consequently something very compelling is required to outweigh it. Again, that's a correct statement. The judge clearly had the public interest very much in mind, and that's reflected in her conclusion at the bottom of paragraph 138, having set out the specific facts of this case. That for all the reasons she set out, this is one of the rare cases where the appellant's circumstances are sufficiently compelling to outweigh the public interest in removal. So in my respectful submission, there is in fact nothing wrong with this decision. The judge did have substantial evidence before her in relation both to the appellant but also in relation to his offending, including the judge's sentencing remarks. She does make direct reference to those and to the fact that there was an extended licence period of 4 years on top of the 8-year sentence. It is the case that she doesn't dwell on that, but in my submission there is no need for her to have done so. Obviously, as the courts have made plain on many occasions, due deference must be given to the specialist tribunal who is the fact finder. I can take your lordships to those authorities, but I'm sure that you are all well aware of them. And this is because of the fact that that is the best opportunity in our judicial system for a full assessment. Because these appeals can take up to 6 hours, oral evidence is given, detailed, there's cross-examination and detailed and lengthy submissions, plus the fact that the first tier tribunal are adept at applying the law in these types of cases. So they have the necessary familiarity. Would it assist to just briefly go through the criteria?
Do you mean for interfering with first tier
Yes.
decisions? I suspect not. As you say, there's a recognition that you have to give deference to the specialist tribunal. Another theme, which is probably in the authorities you've given us, I can't remember exactly, is you don't necessarily assume from the fact that a judge hasn't mentioned something explicitly that they've overlooked it.
Exactly. I mean, perhaps I could just take your lordships and your ladyship to Yauchin, only because that's quite a recent case that you may not have yet considered.
Please.
Just before we leave the FTT,
Yes.
just to put a point to you, because I think what the Upper Tribunal says is wrong, in particular with paragraph 129 and the approach there, is the absence of any recognition that the 8-year sentence was on a guilty plea, so it had a credit for a third. So really you were looking at a start point of a custodial start point of 12 years. I think that's the Upper Tribunal's point, isn't it? I'm just putting it to you just to
Yes.
cover that.
The issue there is if the judge, and I think we have to rightly assume because she said so, read the judge's sentencing remarks, and it would be, I think, helpful to look at those. It's abundantly clear that the starting point, in fact, at the level of offending was life imprisonment. And the judge very carefully sets out all the reasons why he decided to impose the 8-year sentence and the deduction from 12 years because of the plea of guilty. Now, I accept that the first-tier judge doesn't specifically make that point, but she does note the plea of guilty. It is, of course, perhaps, I think, hopefully, commonly assumed that we all know if somebody pleads guilty, they get a reduction in the sentence they would otherwise have received, particularly someone that operates in this jurisdiction. So it's very clear from the sentencing remarks, which I think do set out that otherwise it would have been 12 years, which is why one of the co-defendants, in fact, got more than the other, because he fought and lost at trial. And that's also set out there, which we can have a look at. So I think, yes, on this point of not assuming that they have the judges have read that, and so with the Outchin, so this was a judgment from this year, from 20. I apologise, it's still in. But actually, no, it is in the weekly law report. We have one which hasn't yet made it into the report, but not this one. 2024 1 weekly law reports 1626. This was a deportation appeal in relation to a Turkish national who, like this appellant, had indefinite leave to remain but was convicted of a firearms offence and sentenced to 5 years 4 months imprisonment. The first-tier tribunal allowed his appeal. That was overturned by the Upper Tribunal, and then the matter came to the Court of Appeal, who allowed the appellant's appeal on the very compelling circumstances point. So the relevant aspect in terms of the submission I'm making is at paragraph 50, page 22. And I think it was Lord Justice Underhill. Yes, at paragraph 50, says before considering the reasons of the Upper Tribunal, he is recapitulating the approach to be taken in considering whether the first-tier tribunal made an error of law, and he refers there first to the judgment in H.A. Iraq 2022, 1 weekly law reports 3784 at paragraph 72 per Lord Handlen. I don't think I necessarily need to read it out.
So you might stress little 2 and little 3.
Yes, over the page. And then just moving on from that, also paragraph 51 and the judgment in AA Nigeria, 2024 weekly law reports 145 per Lord Justice Popplewell. And then quite helpfully, at paragraph 52, there was apparently discussion about whether this court should take the same approach with the Upper Tribunal. And Lord Justice Underhill said, in my view, it's clear that the two situations are not comparable, referring back to a different paragraph of AA Nigeria. And it is for this court to reach its own conclusion on whether the first-tier tribunal made an error of law, which is of its nature a question to which there can be only one right answer.
So no deference to the Upper Tribunal on that point.
Unfair on the Upper Tribunal, perhaps,
Yep.
but I think in the circumstances, the point being made is really the one I was making. It's that the first tier gives more time and more consideration in these sorts of cases. So I'm not saying those are all the authorities, but really it's quite a helpful summary of NA Somalia and HOR to deal with that point. So in essence, that's really what I wanted to say about ground one of challenge, as to what we say was an erroneous approach by the Upper Tribunal in overturning the decision of the first tier tribunal for really what we say were marginal reasons. And just, it is also the case that the judge did have in mind both Lord Justice Underhill's judgment in H.A. Rupp, but also the Supreme Court judgment, because she refers to that specifically in her decision and reasons. And I'll just refer to the paragraph number for that. It's paragraph 15, page 108. Albeit the focus there was about exceptionality. But it does mean she was aware of the fact that there had been a further judgment and that she needed to have the time to do it. So moving to ground 2. So this is with respect to the Upper Tribunal submissions really as to why we say that that determination cannot stand, because there are a number of material errors in law, and in particular that in reaching a different conclusion, the Upper Tribunal judge failed to have or take full account of all the material considerations in the case, and failed to provide sufficient reasons for concluding that the public interest in deportation outweighed the appellant and his family's Article 8 rights. So turning to that judgment, slightly confusingly, we have both the error of law judgment from the Upper Tribunal, but it's also been incorporated into the final judgment.
So for this purpose, we can just go to the final one, can we?
I think that's right. And the remaking begins on page 81. Well, in fact, it begins with an unparagraphed reference to section 117C, and then judgments in Zimbabwe and Zulfikar, which we've passed through already. So, paragraph 47, the judge acknowledges the starting point is the findings of fact reached by Judge Head, the first-tier tribunal judge, which are preserved. A finding that exception 2 was met is preserved. The judge then sets out some of the facts, the preserved facts, but not all. I mean, obviously there were quite a lot, but really the ones that are set out on page 82 relate to the exception 2, which is only one aspect, of course, the test being that one has to show compelling circumstances over and above that. So the analysis then resumes at paragraph 52, where the judge says the scope of the remaking is confined to the weighing of the factors identified in the decision of the first-tier tribunal at 126 to 129. Paragraph 53, there's a small error. The judge says, I did not hear any further evidence, although it was drawn to my attention the appellant now had a third child. It was in fact a second child, there is no third child. And then very briefly, the judge says he had submissions from both parties, and then paragraph 56, there's reference to the findings of the first-tier tribunal. Paragraph 57, the judge accepts as a consequence of that returning the appellant to Zimbabwe would be exceptionally detrimental to him. Paragraph 58, he accepts, in light of the evidence and the preserved findings of fact, that his partner is an extremely vulnerable individual, and noted what the independent social worker had said. And at 59, that the appellant clearly meets exception 2 by a significant margin and is now integrated. As indicated earlier, that isn't in itself enough. Obviously the test is higher. And then the judge looks at the public interest factors, paragraph 60 onwards, noting again reference to Zulfikar and the 3 elements. And then over the page 84, there is essentially an extract from the sentencing remarks. And this really deals with rather than what the judge concluded as a result of the offending, the extract here is about the offence itself and the judge's recitation of it. And is in my submission perhaps not really the main focus in itself, given that the issue is that with deference to the sentencing judge, the analysis of how that offending should be sentenced, because that's the reflection in my submission of that reflects properly the severity of the crime when looked at overall.
Sorry, I haven't followed that point.
So, well, what the judge has done here is actually set out what happened, rather than what the sentencing judge made of this. So it forms the factual basis for the sentencing judge's sentence, as opposed to the sentencing judge's analysis of this, which in my submission is the more relevant aspect. And then that's what the sentencing judge's analysis is set out at paragraph 63. Noted the starting point at the very top of the range and additional aggravating factors. And at 64, that the sentence would have been 12 years imprisonment had he not pleaded guilty. I'm not taking issue with either of those. That is a fair summation of what the sentencing judge says. Nor at 65, the impact of offending on people. What I do take issue with is the last sentence in paragraph 55. 65, I'm sorry, my lady, which says the circumstances of this appellant's offending were, in my view, such as to make them significantly more serious than was reflected simply in the length of the sentence, which had been reduced due to a guilty plea. And the reason I do take issue with that is because it was for the sentencing judge to set the sentence, and it's clear from reading the sentencing remarks that he did so with great care and consideration. And it's not, in my submission, appropriate for the Upper Tribunal judge to say, well, he should have had a higher sentence, or it's more serious.
I don't think that's what the Upper Tribunal judge is saying.
But he's...
Isn't all that he's saying that in order to assess the seriousness of the offending, you can't confine yourself to the length of the sentence passed?
On its own.
Yeah.
That is correct, but of course, if one reads the sentencing remarks, which he's done, it's very clear that the fact you had the 4-year extension period and the reduction of the offence from 12 years to 8 due to the guilty plea were material, but that isn't in fact what he says. I mean, this has been a source of contention, I think, in the Supreme Court as well as here, as to, and Lord Carr was concerned, although it was a minority dissenting judgment. I do have copies of Heshamali, as to the weight to be attached to that aspect. And of course, it isn't just. If one just looked at the bare facts of the sentence, that isn't enough. But in this case, we're saying that isn't what happened with the first-tier tribunal judge. And in fact, what has happened with the Upper Tribunal is, in a way, it's almost gone above and beyond filling in what he perceived to be gaps in what the first-tier tribunal said about the offending. And perhaps the right way forward is some balance between the two. Clearly, the context is important as opposed to just the length of sentence. But the first-tier tribunal judge was not basing her decision simply on length of sentence alone. Albeit, when one has a sentence of 8 years, it clearly is going to be very serious.
That I understand, but it seems to me that we may have to be careful to keep distinct in our minds ground one and the appeal and ground two. If you're right on ground one, then that's the end of the case.
Yes.
Actually, the Upper Tribunal had no business overturning the FTT assessment.
Yes.
But for the purpose of ground two, it seems to me we have to proceed on the hypothesis that you failed on ground one, and therefore the Upper Tribunal was free to enter the arena and had to perform the balance sheet exercise again. And what you're trying to persuade us of at the moment under ground two is that the Upper Tribunal erred in law in its approach to that balance sheet exercise. And I understand that, and you're perfectly entitled to make those submissions. But at that stage of the analysis, I don't think we're so concerned any longer with what the first tier tribunal had done.
I'm grateful, my lord, I hear you. So, looking at one will see that there are only two more findings, essentially, at 66 and 67. Paragraph 66, there are three elements to the public interest: the maintenance of confidence in the system, and the deterrence of foreign nationals is perhaps greater than the other factor. Slightly concerningly here, the Upper Tribunal doesn't actually refer to the other factor, which is the risk of reoffending. That had to be put into the balance because there are three elements, so obviously all three elements have to be considered. The first tier tribunal judge had made that finding and it was preserved, but in my respectful submission, that should have been factored back into this analysis in paragraph 66. And then the judge concludes that the truly appalling nature of the appellant's serious crimes and the harm they cause increase the public interest significantly. Now, my submission on this, which I do maintain, is that it's not a term of art. It's unclear, because it's a balance sheet exercise. What does that actually mean when one is carrying out the balance exercise? It is, with all due respect to the Upper Tribunal judge, perhaps a little vague or unspecified in terms of how it's been put. So it would appear from the next paragraph that what in fact he was finding was that the public interest was so significant that it outweighed everything else. But if that's the case, then in my submission he should in fact have said so, made that plain, and perhaps added more by way of reasoning as to why he reached that conclusion. I accept over the previous page he set out the basis of the claim and the sentence and some of the analysis by the sentencing judge.
I mean, you're both here, to an extent, looking both ways, because at the stage you're challenging the interference with the first tier decision, you say, well, you assume the judge in the first tier got it right. At the stage when you're challenging the Upper Tribunal decision, Mr. Tabori might be saying, well, we assume the Upper Tier took everything into account.
I'm sure Mr. Tabori will be saying that. But what we say is in essence, with respect to the Upper Tribunal judge, the reasoning really is somewhat scanty, given the vast importance of this appeal for the appellant, his partner and his children, and of course because more generally in terms of the public interest factors, it is in my respectful submission necessary, unfortunately, to set out in perhaps more detail what the factors were for and against. And really, when one reads this, particularly given the factors in the appellant's favour, which are to some extent but not entirely summarised on page 83, it is unclear why the judge concluded that the public interest outweighed the factors in the appellant's favour, given what those factors are and given the preserved findings of the first tier tribunal judge. Now, obviously, had the Upper Tribunal judge been making this decision afresh and making his findings, that it would have seemed much clearer. But it doesn't in my submission sit well, and it does, when one reads it, give the impression that not all of the considerations that were material have been taken into account, and the reasoning simply isn't adequate to justify the conclusion. So I don't wish to take up undue amounts of time. You have my written submissions, but really, and I'm not at all deploring the shortness of the judgment. Obviously, short judgments are a good thing, but in some cases, and this was one of them, more was needed in my respectful submission. Unless I can assist you further at this point.
May I just correct one thing I said earlier? I don't think it's going to matter, but I just wanted, in fairness to you, to say I've been thinking again about the sentence that was
Yes.
passed. I think you're right. If the sentence was 8 years, then if it was passed in 2013, then probably the entirety of the sentence will have expired some years ago, including the ordinary licence period, and therefore the extension period of 4 years, probably.
February 2024.
Yeah.
Yes.
So I don't know if that affects your submissions. I don't think it does.
No, because our position is there has been no reoffending or any issues arising, which was made clear in the evidence. Grateful, thank you.
Thank you very much. Mr. Tabori.
Thank you, my lord. Round one, we say, is very straightforward. And in fact, I'm saying that merits and how you should decide this appeal is very clear with respect to both grounds. But in terms of ground one, the error of law ground, we say it's very clear. Indeed, I don't need to go back over particularly the judgments because my learned friend's helpfully taken you through them, but we say on the face of paragraph 129, it's clearly inconsistent with the Supreme Court authority that I cite in my skeleton argument, namely H.A.R. Lord Hamlin. The specific, what Lord Hamlin said was that there are other factors, and he had in mind the fact that section 117C2 is broader than just the numbers game of the two exceptions. But the specific example he gave was the issue of the presence of a guilty plea and reduction for it. We have that specific additionality here because of the reduction of 4 years from the otherwise top of the range 12 years, or near top of the 13 year was the top. But we also have other factors, and the two other factors, which are less clear cut, and I don't need to rely on them, but we say are present, are the extended licence period. And this was made at a time when adults could have these extended sentences, and the sentencing remarks show very clearly the application of the criteria for the same, namely specified offence, aggravated burglary. I don't, off the top of my head, remember the other ones, but I can take you to where the sentencing judge applies them. But the third is the nature and seriousness of the offence. So both in H.A.R. Lord Hamlin's judgment, but also in Sanim, pronounce it correctly, in Sanambar, another Supreme Court judgment, Sir Declan Morgan at paragraphs 51 to 52, which I set out at paragraph 20 of my skeleton, considers the Strasbourg judgment of Anani and considers how the circumstances of the offence bear on should also be taken into account. And what's particularly notable about both judgments, so quite apart from the clear principles in those cases, the fact that they're Supreme Court, so pretty authoritative, is the facts of the discussed in those two cases, which obviously doesn't, we're not looking at factual precedent, but it is particularly clear pointer to how we should approach it here. So in H.A. Iraq, at paragraph 68.
So this is, at least for those in hard copy, tab 4, as it's in the authorities bundle. Yeah.
Yes, exactly. So the sentence beginning in relation to short sentences.
Sorry, which page are you?
Sorry, paragraph 68, which is 65 of
Got
the
it.
authority.
Yeah.
So the first point is that Lord Justice Underhill said that focusing on essentially more than sentence length was an inappropriate degree of refinement. Lord Hamden says he disagrees, and then he says, in relation to short sentences, its impact may not be great, but in relation to longer sentences, it may be considerable. Take, for example, a jointly committed robbery under which one offender received a sentence for 9 years and the other, after an early plea, received a sentence for 6 years. Now, here we don't have robbery, but we do have aggravated burglary, and it's not a short sentence, it's a longer one than given in this example. It was 12 to 9 rather than 9 to 6. So I think that's a helpful corollary with why that issue applies here, if it were needed, and the sort of factual guidance perhaps that's gained in Sanambar, which is tab 6, paragraph 51. It's on page 113 of the authorities. We see, first of all, we see the importance of considering the particular circumstances. And then, fourth sentence, the first step was the consideration of the nature and seriousness of the offences. These were knife-point robberies at night of victims aged 15 and 18 years, pre-planned against vulnerable young victims who are likely to have goods of value. It is clearly a circumstance of relevance for section 117C2 purposes, and well, that is my point on ground one. That is why it was necessary to consider it. And in terms of turning to the first tier's judgment and learning from effectively attempt to show that in fact the first tier charge wasn't confining herself to that. I say that's an impermissible reading of what's said at paragraph 129. Sorry, what do I do?
So can we just try breaking it down a moment? You would accept, would you, that the first tier judge had read the sentencing remarks?
Yes.
And that she therefore would have had in mind that there was a 4-year reduction for the guilty plea and that there was an extension period?
Potentially. Applying a presumption, then yes, but we don't know whether in fact.
We may not know, but if one adopts the approach that one normally adopts to judgments and decisions, one would proceed on the basis that she had all those things in mind. I mean, she evidently had read the sentencing remarks, and she says that at all stages she took into account all the materials. So your complaint has to be, does it, not that she didn't have all these things in mind, but that because of what she said in paragraph 129, she can be seen not to have attached significance to those matters in assessing the seriousness.
Yes, it's the... Sorry, what you were going to say?
Now, sometimes decisions of first-tier tribunals are rather less well written than this one. And then the Secretary of State might be saying to us, look, you can't attach too much weight to every word that a judge says in the first-tier tribunal. They must be assumed to be doing it right.
Yes.
You obviously don't say that here.
No, quite, because, and you sort of intimated at what I will be saying on ground 2, when the shoe's on the other foot, if you like. But on ground 2, just to use it as a contrast, there's not the clear-cut misdirection. We say that the statement here, the only indicator of the seriousness of the appellant's offending is the sentence imposed, is absolutely clear. And my friend took you to authority saying that on the question of error of law, you don't defer to the judge below. Well, by the same token, you are interpreting this for yourself. There's no sort of margin or something. So, and the plain meaning of that is to the exclusion of the mandatory relevant consideration expressed in HA Iraq. So it's not a question of can we assume that it was in the... If it wasn't expressed in those terms, maybe it would be different. But this is express confinement.
I mean, in another sense, you might just be saying, look, it's obvious that this was really serious. You know, it doesn't matter to me whether it was 8 years with an extension or 12 years. It's just really serious. I can see that.
Yes. Well, if I could just, so within the same single sentence on seriousness, to really go for the sibilants, the judge says the only conclusion that can be sensibly reached from the sentence of 8 years is that this was serious offending. But of course, there's seriousness, there's serious and the quantity of seriousness effectively. To be a serious offender, you just are over the minimum threshold effectively of more than 4 years. But then there's quite a big difference between those who are just over the threshold, if you like, and this. And we can see the different that it matters effectively how a judge expresses these things from the contrast of how the upper tier describes it when remaking, talking about the appalling nature of it and so on. And that matters in this particular jurisdiction of deportation law because of those three factors of deterrence and public condemnation, etc. And I think why we know that it is an error is perhaps the more revealed or confirmed by the fact that my learned friend in her submissions on ground 2 appeared to criticise the upper tier judge for looking at the guilty plea issue rather than just the sentence imposed, which appears a misunderstanding of the failure by the first tier. So it's either a repetition of the same error or a defence of the error. But it's either way, it's hardens the presence of the error. And the reference to Hesham Ali, which I've been provided a copy of, and I'm told the relevant paragraphs are 168 and 169.
Now, I don't think we've yet been given this, have we?
I can certainly hand some up
Please.
if that would assist. One of them seems to have lost its tab.
And you gave us a paragraph reference a moment ago, Mr. Tabori, and I've forgotten what it was.
It was paragraph 168 specifically, I'm told. In 168, if you want to briefly read it.
Yes.
My lords, my lady.
And
I'm told 169 is also relevant, but for the point I'd like to make next, it's just 168.
Shall we, for convenience, read the two
Yes.
paragraphs? remind me, at this stage we're dealing with the judgment of who?
Carl,
Carl. Yes, I see.
Yes.
Was he dissenting?
dissenting.
Yes.
Yes.
So the point being made at 168 is that there's no room for taking into account expressions of additional revulsion.
On the ground of nationality. There is no rational basis
Yes.
for expressing additional revulsion on account of the nationality of the offender. Which must be clearly right.
Yes.
I mean, you don't assess the seriousness of offending by reference to the fact that it's a foreigner or not. It's equally serious whoever commits it. That's the point Lord Kerr is making, I think.
It's only the point of the last sentence.
Yes.
It's so clearly the point in the
First
preceding sentence.
Yeah.
No, you're absolutely right, my lord. I mean, I haven't heard my friend didn't particularly develop the point, but I understood the point to be being made, and if it's not, then it doesn't add anything. But that, given where it was raised in relation to, namely this issue of you should look at sentence number, years alone, is that this the additional qualities, for instance, a sentencing judge who really goes for it in the language is not a relevant consideration, and that has to be right. And we see the sort of thoughts of Justice Underhill in H.A. Rugg. But that is to be distinguished, I would say, from the more objective measures that we have of the presence of a discount, the extended licence period. But my Lord Justice Singh, you may be absolutely right. That's not what actually is being said there. And
Well, it may be.
I mean, even without that, I am assisted by it simply to say that we're not talking about that. It's not simply look how angry the sentencing judge was. These are proper relevant considerations, but I don't have to persuade you of that. Effectively, we have the Supreme Court saying so.
I've got on board the point about your point that you do need to take account of discount for guilty plea, and you do need to take account of the type of sentence. In this case, it was an extended sentence. Is it also your submission that the nature and circumstances of the offending is something that the immigration judge can look at afresh as part of their public interest balancing exercise, or I'm not quite sure where we are on
My
that.
lady, I would accept that that is the less clear cut, because we see from the sentencing judge's remarks that when they come up with a figure, they take into account some of the circumstances already. So that, to that extent, it's already factored in, and you can't double count it on top. The judge refers to multiple victims, multiple offences, but nonetheless, and this may be sort of more of a problem for you, given I don't depend on it, that you may not want to confront it or not, but we do see from Sanambar, the Supreme Court authority, that circumstances
that's
are
what I
relevant.
thought you were saying.
Yes, so quite, and I don't withdraw it.
The point that the
Yeah.
former Lord Chief Justice of Northern Ireland was making in the passage you showed us was that if you simply go by raw numbers, you will not necessarily appreciate the full gravity
Yes,
of the offending.
yes,
So, for example, the example that Sir Declan Morgan gives is where a sentence is heavily discounted because of the youth of the offender.
yes,
But he says that doesn't necessarily tell you anything about the nature and circumstances of the offending. So if you simply said, oh, well, the sentence was only 3 years detention, that's the example he gives. You wouldn't necessarily understand the true gravity
absolutely.
of what somebody's done.
That is quite a clear-cut example, almost akin to the discount for the guilty plea example, because it's a discount for them being a minor, which doesn't apply here because the appellant was just over 18 at the date.
Well, it doesn't, but nevertheless,
But it's broader than that.
what's become clear, perhaps it wasn't so clear in 2013, although I would hope that actually sentencing judges were taking this into account even then, but it's now since been confirmed by the Court of Appeal Criminal Division that 18 is not a cliff edge.
No.
And so sentencing courts, certainly nowadays, do, perhaps in 2013 they did, reflect the fact that somebody had only just turned 18.
Yes, and we do see presence in the sentencing remarks of apparent regard to, although it's slightly unclear at points because the judge is also talking about the other two defendants. I won't spend my time on that. What I would say, my lord, on just further to that point, and why unquestionably, and my lady's point too about circumstances, nature and seriousness being part of the package, even if slightly less hard-edged than the presence of extended licence period and the guilty plea, is the fact that back in Lord Hamlin's judgment, again at paragraph 70, so it's tab 4, page 66. That's derived from, as I mentioned, Newey in Strasbourg at 67, and they set out there, the court has tended to consider the seriousness of a crime in the context of balancing exercise not merely by reference to the length of the sentence, rather by reference to the nature and circumstance of the particular criminal offence, and then adds at the end, the court has consistently treated crimes of violence and drug-related offences as being the most serious end of the criminal spectrum. So it comes from on high, as it were, from some original principle.
Just as we look at this, it does seem that passage you've just taken us to from HA RAC 70 contributes quite a bit. But it would make sense, wouldn't it, that the immigration judge is conducting a public interest balancing exercise pursuant to statute and is trying to weigh the seriousness of the offending in that context, which is a very long way away from what the criminal judge in a Crown Court is doing. So there's obviously an interplay between those two exercises. You're looking at the same facts and the same events, but the context in which those judicial evaluations are taking place are entirely different, and it would be odd to tie the immigration judge's hands unduly by what the criminal judge had said, when criminal judges have to think about a whole plethora of things that immigration judges don't have to think about, like clemency or all sorts of things that you might have in your mind, and vice versa.
Yes, no, absolutely, and quite apart from anything else, it's a balancing exercise. It's not merely just a statement of all the punishment and why the punishment.
Exactly, it's a public interest balancing exercise, which is not something really a criminal judge is doing.
No, quite. But in terms of the immigration judge's task, they very much are being told, see these Supreme Court authorities, to start from the sentencing remarks, effectively to take their cue from them. So that within HA Iraq again, which is almost the answer to this ground one, that so paragraph 67, page 65 of the authorities bundle, is the answer to Milady's question almost. In practice, however, an immigration tribunal may have no information about the offence other than the sentence. And my Lord was just saying what the point about the guidance to sentencing judges now, whether it's because an immigration judge may want to consider it or simply because this is the way to give sentencing remarks. But and if that's the case, Lord Hamlin said, that will be the surest guide to the seriousness of the offence. But we're not in that scenario here. We have sentencing remarks. We don't just have the total. And then Lord Hamlin says, even if it has the remarks of the sentencing judge, in general, it would only be appropriate to depart from the sentence as a touchstone of seriousness if the remarks clearly explain whether and how the sentence has been influenced by factors unrelated to the seriousness of the offence. So that's the guilty plea point. So we're in that.
Bit, I mean,
yes.
With all due deference, obviously, to Lord Hamlin, it seems a bit giveth and taketh away, because 67 seems to be saying, if you've got the sentencing remarks, that's your touchstone. What I understand by touchstone is really that's your start point, but except in odd circumstances, is probably your end point as well. And then there seems to be an invitation in 70 to say, but you do need to look at the seriousness of the offence. I mean, I don't think it's necessarily inconsistent, but the notion 70 is you can go a bit further than the sentencing judge did because you're doing a different exercise. That's what I understand from 70.
Yes. Yes, it does seem slightly broader than then the touchstone point in 67 I would accept. I just relying on 67 here to say that the sentencing remarks are very much a mandatory consideration, essentially, where they've been provided to you.
So the thrust of your submission is, okay, we can assume that the first year judge had in mind all these different things, but when she actually came to assess the seriousness, it's apparent that she wasn't taking into account, for example, the guilty plea, and we know from HA Iraq that that's wrong.
Yes, absolutely. Yes, it's the difference between. I mean, I don't have to show, and the upper tier judge didn't have to show that there was material disregard, even, and failure to sudden forgetting of matters that may have been read, because the approach, the machinery, the mechanics of the exercise of the application of the test for seriousness of the offence was wrong, was a misdirection.
I note also that Lord Hamblin expressly cites Sanambar at paragraph 71
Yes.
of his judgment. It seems with approval.
Yes. I mean, it could be, my lord, that this, because the sort of main, as I said before, specific example given is the guilty plea example, and that everything else is slightly less clear, albeit it's very clear that it's broader than just numbers, and it's not confined to the guilty plea issue, because 117C2 is broader. That the answer to that question of what then else is it, is this extended license, extended sentence example, because that is not about the seriousness of the offence necessarily. It's an assessment based on an assessment by Joyce Lawmaker, I think her name was mentioned in the sentencing remarks, of the dangerousness of the individual and the specific additional statutory criteria for imposing that. That does reflect and incorporates issues of the acquisitiveness that the judge said he was concerned by, this repeat aggravated burglaries and so on, the recruiting of these individuals. That's not just multiple offence, multiple victim. That is a separate additional exercise. So rare as this may be, and it may not be that helpful for other cases, deportation cases, it's a pretty good example of when nature and seriousness is present as an additional factor, albeit it means it's the same factor, rather than extended licence is one thing and nature and seriousness is another. Is one way of putting it. My lords, you have my skeletal arguments. I don't propose to say more on ground one.
No.
On ground two, I'll start with points by my learned friend. Again, this is the shoe on the other foot point, really, and go back to Yalcin just to express it, which was tab 2, and specifically paragraph 51. Within that, you were taken to. So the first 51 is the reference to Lord Justice Popwell in AA Nigeria, experienced judges and specialised tribunal to be taken to be aware of the relevant authorities and to be seeking to apply without being to refer them specifically unless it's clear from the language that they failed to do so. And perhaps even more clearly, preceding paragraph 50 from Lord Hamlin again, it's in AA Nigeria and the principles set out there. And these of course very important. Subparagraph 1, so at the bottom of page 22 of the authorities bundle, it's about, well, I'll read it. They alone are judges of the facts. The decisions should be respected. It's quite clear they've misdirected themselves in law. And then subparagraph 2, where a relevant point's not expressly mentioned, another tribunal court should be slow to infer has not been taken into account. And then 3, when it comes to the reasons given by the tribunal, the court should exercise judicial restraint and should not assume the tribunal misdirected itself, because not every step in its reasons is fully set out. So particularly helpful here, because Roman numeral 2 is relevant considerations, Roman numeral 3 is reasons, and those are the two twin prongs of this ground 2 argument. and there isn't the error of law point that we very much see in relation with we're considering on ground 1. The point at 52 about it doesn't apply to the Upper Tribunal, you'll recall, because it's not a sort of primary fact finder, doesn't limit what I'm saying here in this case, because this is a challenge to the remade fact-finding decision, not your review on a second appeal, effectively, of an error of law decision. Yes. The second point is that I would submit that my learned friend's very clear and fair, taking you through the reasoning of the Upper Tier Tribunal judgment, particularly 56 to 59, showed clearly the quality of the consideration, the comprehensiveness of the consideration performed under the balancing exercise. No shying away from the extent of impact on the child in question, or the impact on the appellant in terms of returning, expressed in almost as strong terms as in relation to the offence. So there's no question of disregard of anything, playing anything down. My learned friend accepted that there was a fair summation of the sentencing remarks, but that came finally to say that in respect to paragraph 65 of the judgment, that if we just go to that to remind ourselves what that is. So core bundle 85.
Sorry, which page?
85 core bundle, paragraph 65. Here the upper tier judge says something about burglaries, significant aggravating factors, and then the sentence that my learned friend took issue with. The circumstances of the appellant's offending were, in my view, such as to make them significantly more serious than was reflected simply in the length of the sentence, which had been reduced to a guilty plea. And here was the point where I say my learned friend is repeating the first tier's error, which you may not find as an error depending on how you decide ground 1, but Smith strongly was an error. In fact, correctly applying the authorities, hierarchy, etc., the upper tier tribunal was fully entitled, actually required, to have regard to the issue of the role that the guilty plea had here in relation to the length of sentence.
Mr. Tabori, can I just ask you, so that I understand myself how this fits into the statutory framework? Have I got it right that the statutory presumption in favour of deportation of a foreign national criminal applies if they've been sentenced to a sentence of at least 4 years imprisonment?
I think the presumption applies for 1 year.
Right, okay.
And then there's subsequent to that, there's a division, demarcation between between 1 and 4.
Right.
And then 4 and upwards is the over and above, very, very compelling circumstances, over and above.
That's what I was thinking of, that particular statutory provision. But is it part of your submission that even if you cross that threshold, that can actually embrace a wide variety of circumstances?
Yes. Yes, that is my submission.
And that, as my lady was alluding to, I think earlier this morning, that the judicial context or the legal context in which these exercises have to be performed is not the same. One of the things I have in mind is that it seems to me one has to be slightly careful about the word dangerous. As I understand it, Parliament has taken the view that anyone who has crossed the threshold of a particular length of sentence is presumed to be a danger to the community in the United Kingdom.
Yes.
I understand that conceptually, that's not necessarily the same thing as what a criminal court is thinking of when it's passing a sentence, which is specifically to cater for the dangerous offender.
Yes.
Because you can have, for example, a determinate sentence of 10 years in prison, let's say. But you haven't decided that person is a danger to the community in the criminal sense. And yet, am I right in understanding that within the immigration statutory framework, that would still be regarded as being someone who's a danger to the community of the United Kingdom?
I would say that's my understanding,
Yeah.
my lord, that whether it's the three considerations or the three public interest purposes would bring that into account. Whether it's the judicial dicta, which are very confident following Strasbourg that it's a broader exercise than just the numbers game. And the very fact that on 117C there are these additional categories, effectively dividing up the foreign national offenders for whom there is already a presumption, shows that Parliament is at pains to create broad, bright lines, even if the immigration judges then themselves are entitled to divide it up even more effectively, so as to consider the differences within a given category. So I don't think, certainly my friend doesn't argue, and I don't think it would be correct on the authorities to say that the immigration judges are, despite not performing the same involved exercise of applying sentencing guidelines and specific guidelines on dangerous offenders and so on, a far more involved exercise than any immigration judge would do. And we see from Lord Hamblin and HARR that it's very much secondary to and confined by what you have from the sentencing court. So if the sentencing court if you don't have their remarks, or for some reason, I don't see why they wouldn't exist, but if the immigration judge doesn't have them, you can't go on a frolic of your own and do it instead. So there's very much that secondary element, but you are expressly enjoined to apply within the limits of your statutory scheme and under the Act that information that comes to you from the sentencing remarks. And the judicial dicta that I say that brings it into, puts another way that the fact that it bears on this question of whether there are very compelling circumstances over and above, namely how the seriousness and nature of the offence bears on that question. I think what puts it quite well is Sir Declan Morgan in Sonambar at 52, tab 6. 52, page 113.
Yes, thank you.
It was recognised that although the 2002 Act and the 2014 rules did not expressly require consideration of the circumstances of the offending, it was necessary to do so in order to consider whether there are very compelling circumstances. So essentially it's not just how serious is the offence, look at all this extra stuff beyond sentence length, but the very question, statutory question being applied, 117C6, are there very compelling circumstances, takes into account the nature and circumstances of the offence. Just a discrete point regarding what was said about paragraph 66 of the judgment, which is core bundle 85. It was said, somewhat in passing, that the statement there are three elements to the public interest then didn't state them all. Judge said, in this case, the maintenance of confidence in the system and the deterrence of foreign nationals, so that's two, is perhaps greater than the other factor. So that's the reference to the third, so clearly with three in mind. And then just lastly, on Willifred's closing point, that the upper tier judge should have added more by way of reasoning is not the test for a reasons challenge, and in particular cannot succeed in the context of the statements that I took you to from.
Nelson.
Yeah.
Well, the other trouble is it's quite hard to know how you could say more in a way. I mean, if your view is, look, I appreciate that there are all these problems, but it's truly appalling, I'm not quite sure how you elaborate on that.
Yes. Yes, I mean, if you find that returning in these circumstances would be very harsh, and you find that the impact on a relevant child who's in the frame would be harsh, and yet you find that the offending is extremely serious, you've had regard to everything, effectively, and then how you weigh it is your discretion ultimately. The point I haven't made, but perhaps I should end on, given your question, my lord, is what's said in Yalcin at 40. That's tab 2. Page 19. The UT, as we know, reached a different conclusion about proportionality when it came to remake the decision, so, as here, hopefully. And it might be thought that the way that the first tier struck the balance in this case was generous to the appellant. However, that in itself cannot constitute an error of law unless its conclusion can be characterised as perverse. So, all right, proportionality isn't a sort of deferential space like irrationality, but in an appeal from it, you afford some ambit and allow for the fact that you may have struck the balance differently.
A moment ago, you used the word discretion. I'm not sure you meant discretion as such.
No,
I think
it's not a discretion. It's a right answer.
It's assessment.
Answer. Yes, exactly.
The word used in paragraph 40 is assessment. And I think that's what you're getting.
Yes, thank you.
As Lord Underhill said there can be circumstances in which different judges would reach a different assessment on the same facts.
Yes, absolutely. Clearly, these two judges did. The only problem is why it's before you is that the first tier may have done so, in fact, very much did, because of shaping the exercise, framing the exercise wrongly.
And just picking that point up, you say, well, we can see the error of law in the first tier. We don't know whether it would have made a difference had the first tier judge had in mind the correct masses.
No.
But you say that doesn't matter because we can't know that it would have made no difference.
Yes. Yes, I think that puts it accurately. Yeah, indeed, the upper tier had regard to the materiality question and considered that.
Yeah.
See my skeleton at 29.
Yes.
Unless I can help you any further, my lords, my lady.
No. Thank you very much, Mr. Spory. Ms. Chapman.
My lord. The starting point of the first tier tribunal judge was in fact the Secretary of State's refusal decision, and I became aware whilst listening to Mr. Tabori, that we haven't in fact had regard to it, but it may assist. It's just before the sentencing remarks, so it starts on C4 of the supplementary. And the reason this is the starting point is because it's the refusal that triggers the appeal. It sets out the Secretary of State's case on the appeal. and I just wanted to highlight three aspects of it. So the substance starts on page C7.
Yes.
Paragraph 2, you were convicted of aggravated burglary on the 24th of September 2013. You were sentenced to 8 years imprisonment in a Young Offenders Institute with an extension period of 4 years. That's repeated at paragraph 19 over the page C8. And then at the bottom of C8 through to about halfway down C9, there are extracts from the judge's sentencing remarks. And the middle of C9, paragraph 22, you have the reasons that the sentencing judge concluded that an extended licence period is necessary, both for the protection of the public and for the eventual rehabilitation of you, which in fact will amount to the same thing. And then at paragraph 25, the Secretary of State then imposes a Section 72 certificate that's already been addressed. So the reason I draw attention to this is, firstly, obviously, this decision would have been very much in the mind of the first-tier tribunal judge, and it also represents the Secretary of State's decision and reasoning for the deportation decision and for refusing the human rights and protection claims. The Secretary of State could have said more, but I'm not sure if it was a he or she at the time, but didn't. But the judge, in my respectful submission, was not required to necessarily go above and beyond what was being submitted to her by the Secretary of State, who clearly plays a key role in the appeal, both in the refusal decision and at the hearing. And you have reference to the submissions made by the Secretary of State. So I'm just highlighting really what was before the judge and that she was required to determine as her starting point. And just a few more brief points. It isn't abundantly clear when one looks at the impugned paragraph of the judge's decision, first-tier tribunal judge's decision at 129, page 126, that whether the reference to the sentence imposed in light of what we've seen in the refusal decision and in light of the judge's earlier findings is to the sentence overall of 12 years reduced by 4 years by a guilty plea, or simply to the 8 years. And I would submit that it's the former. The point, in essence, that the first-tier tribunal judge was making again here, though, was that she was well aware of the seriousness of the offending, whether it was 12 reduced by 4 or simply 8. But the point is made 3 times in the refusal decision, and she refers to it twice earlier in her decision. Similarly, in relation to the guilty plea, that is expressly referred to by the judge in her analysis, and that's at paragraph 27, page 110. We say there are no errors in her decision, even if she had and essentially even if she had focused more on the second 2 criteria in Zulfikar, which she does refer to, and the points made by Mr. Tabori, it would not have made a difference, given that throughout her determination it is characterised by her acknowledgement that the offence is either serious or very serious, which she also says on a number of occasions. And as she concluded, it was a rare case because of the issues relating to not only the appellant himself, but his partner and the impact on the children, which was set out in the report of independent social worker. Turning to the decision of the upper tier, I just first want to correct the factual point. One of the concerns as set out in my skeleton argument is that there is no reference to the impact on the children. There was one child at the time before the first tier tribunal judge. She was the focus of the report of the independent social worker. But at paragraph 58, page 83, the only point being made there in relation to his daughter was their inability to live in Zimbabwe. But the finding as to extreme vulnerability related to his partner, there is no acknowledgement of the role of section 55 and the best interests of that child, and in fact the second child, who he mischaracterised as the third child at paragraph 53, page 83. That is of concern given the statutory obligations relating to section 55 and the best interests of children in the UK. Of course, these are also British children. They should, at least in my respectful submission, have merited a mention. This is one of the reasons we say that the judge did not correctly conduct a compliant balance sheet exercise. In terms of the challenge...
Forgive me for interrupting. Suppose we were to accept that submission, what would follow? What order should this court then make if we accept that argument?
So rejecting ground one but finding in favour of that point on ground two?
Yeah, or more generally on ground two.
Well, if you weren't with me in respect of ground one, there would have to be a remittal and a rehearing, I think, on that basis.
I think we could do it ourselves if we felt so minded, because we have
My
those
native-
powers,
yes,
but,
of
or we
course.
could remit to the Upper Tribunal,
Yes.
presumably,
Yes.
to correct that mistake.
I mean, of course, your lordships and ladyship could, but you may not wish to spend the time. But you could substitute your own judgment for that in the alternative. And just on the Yelchin perversity point, we say this isn't a perversity challenge because it's not to the outcome, but to the process. And we say it's the process, the balance sheet assessment that's flawed rather than simply disagreeing with the outcome, which is different from the first tier tribunal. And just lastly, in relation to the point about paragraph 65, page 85, and the length of sentence. My point is that the first tier tribunal judge did clearly have regard to more than just the length of sentence. And that's clear from her reference to the sentencing remarks of the criminal judge and the reduction of the sentence by virtue of the appellant's guilty plea.
Which paragraph are you on, sorry?
Sorry, this is the upper tribunal judges, the last sentence of paragraph 65, where the point is the judge is making is that the circumstances mean that the sentence, that the offence is more serious and is reflected in the sentence. So it's an issue of contention in the sense I said really he should defer to the sentencing judge. And there was discussion as to the fact they're different roles, which they are, the tests are different. But I would submit it's perhaps a bit dangerous for a judge to try and go above and beyond what a sentencing judge has found in his capacity, given it's a different context and a different assessment that an immigration judge or upper tribunal judge has to conduct. Unless I can assist you further.
No, I don't detect any further questions. So thank you both very much for very well constructed and economical submissions. We won't give judgment here and now. You will be provided with a draft in the normal way for you to point out errors of typing and English, but not, of course, to re-argue the case. We'd be grateful if at that stage you would seek to agree an order dealing with consequential matters. If there are any points on which you disagree, could we please have brief written submissions, and we would expect to rule on the points in the order that we make. Lastly, I ought just to remind you of what I know you will anyway be well aware of, and that's the importance of the embargo, to which great importance is being attached. So were it to be the case that you thought that the draft judgment should go to anybody who we don't already know about, please come back to us and get permission for that to happen.
Of course, my lord. And just for clarity, because this has come up, presumably one can share it with one's instructing solicitors, but that's it. Because it only comes to counsel.
Yes, no, well, I think that's absolutely right. And while I can't remember seeing a contact form in this case, I assume one has been submitted. And I would expect that to include the instructing solicitor as well as obviously counsel. So thank you both very much.
Advise, David.